Okay, welcome everyone. I'm glad to start the second part of the State of Social Assistance in Africa webinar series. And thank you to socialprotection.org for hosting this session. My name is Liya Abraham and I work at UNDP's Regional Service Center for Africa on the social protection portfolio, and I'll be moderating today's session. Just to provide a little introduction before moving on to the content. As you probably have read, the webinar series is based on the State of Social Assistance report that was published 2019 by UNDP in partnership with the African Union, in collaboration with ILO, UNECA, and UNICEF. And to give you an idea, the report reviews trends in social assistance growth in African countries across 3 foundational dimensions, which are legal frameworks, financing, institutions, and this is based on a most comprehensive data set in this area. The key takeaways of our report were that there's a rising ownership of the social assistance agenda by African governments, as well as a rising number of social assistance programs. There is a rising commitment to domestic financing for social assistance, which now on average exceeds donor financing in African countries. And the fact that social assistance is increasingly being recognized as a right in national legal and policy frameworks. So this is what this session today will be focusing on. It will focus on the state of legal frameworks for social assistance in African countries. I think the current crisis has exposed the importance of social assistance systems in creating resilience to crisis and strengthening countries' ability to respond to disasters. It has also exposed to us how many people are left out of national social assistance systems and have no right to claim social assistance in times of need. Yeah, in light of this, the second webinar is dedicated to discussing the state of legal frameworks on social assistance in African countries, and also exploring the implications African countries' legal frameworks have on their COVID-19 crisis response. And for that purpose, our first presenter, Marius, Director of the Institute for Social Law and Policy, will start off the session by providing us with an overview of legal frameworks and social assistance in African countries and looking at national, regional, and international frameworks, among others. We shall then move on to our second presenter, David Stewart, the Chief of Child Poverty and Social Protection at UNICEF, who will delve into how African countries' legal frameworks and social assistance have affected a country's response to the current crisis. And last but not least, Sarah Rattray, Global Specialist for Human Rights at UNDP, will finish up by presenting her thoughts on why a human rights-based approach to social assistance is important. So thank you, everyone. Thank you to the panelists, and thank you for those of you who have signed up to participate. Please, throughout the session, share your questions, interact with us in the chat bar, but also on Twitter using the hashtag SP.org-webinars. And we will end up the session with a Q&A session where you can ask questions, and we will answer these questions. Thank you, and over to our first presenter, Marius.
Thank you, Liya, and colleagues, it's my pleasure and privilege today to speak to you on legal frameworks informing social assistance in Africa. In fact, what I'm going to present to you in part is a kind of a summary of the chapter on the legal frameworks contained in the report that Liya referred to, the state of social assistance in Africa. However, in the see on the next slide, the overview, we actually will start off by looking at what's happening in the COVID-19 spectrum or dimension, and try to link it to our discussion. So it looks like a very long overview, but we're mindful of we'll move quickly through the slides. We can move to the next slide, which actually deals with a recent a table or figure that we have. The next slide, please. Composition in COVID-19 related social protection measures, Africa in comparison with other regions. And the interesting thing that we immediately see there, and which highlights the importance of our discussion today, is that in the COVID-19 context, the measures, or let's say then the additional measures taken by countries in Africa, by far are of a social assistance nature, about 84% of all programs. It represents the highest percentage in this regard of all areas or all regions in the world. And it tells us how dependent Africa actually is on social assistance measures, and how weakly developed for the moment social insurance and other arrangements are. The next slide actually drills down a little bit more in detail. The next slide, please, on the social assistance measures themselves to see how they are made up. And we can focus on Africa, and we see that, and again, the picture is a bit different from the rest of the world, that more or less, there's almost an equal distribution as far as cash-based measures are concerned, in-kind based measures, and other social assistance measures. So there is, interestingly, quite a large percentage of in-kind and other social assistance measures, which I think will then be explained in the next slide on another figure that we have. If we can turn to the next slide, that gives us a little bit of a breakdown of COVID-19 measures as far as social assistance is concerned. Now, this is Sub-Saharan Africa. Of course, it doesn't include North Africa, but nevertheless, I think it provides us with some idea there. And at the bottom, you can see the cash transfers measures for COVID-19. They reflect or represent 32% of all measures. The in-kind transfers, 28%. But so how's the rest then being made up? You've got a school feeding program, support to all kinds of support to informal workers, tax relief, utility relief, and then public works. And it is in those four areas, so from school feeding up, that we really see where Africa kind of, to a very large extent, has to do more than what's happening elsewhere in the world, perhaps given the lack of resources too. So to summarize, thus far, I think we really have to be aware of how critically important social assistance is for the continent, especially in a time like this. But even if we move on to the next slide, please, you will see that even so, in comparison with what the rest of the world is able to do in terms of the number of people they provide for in social assistance, we find that Africa is astonishingly one of the few regions where a very small percentage of the population for the moment are benefiting from additional COVID-19 related cash transfer programs, typically part of the social assistance context. May 22, according to the source cited, only 2% of the African population thus far, or that far, have been benefiting from the COVID-19 specific social assistance or cash transfer measures rather than social assistance in a broad sense. So now we can move to the next slide and talk about social assistance from a rights-based perspective, because I think that is the core of what we see increasingly happening in Africa. And perhaps to summarize, I think the short of the story is that whereas in the past, and even a very recent past, 10, 15, 20 years ago, much of the social assistance provision in Africa was, with few notable exceptions in the continent, much of the social assistance provisioning was actually kind of based on programs, on the exercise of discretion. But clearly, increasingly, we see a rights basis being developed, a human rights basis, if you like. We see this reflected in the constitutional uptake of that, and even in national laws, and the increasing influence of some of the international instruments. We'll talk to some of that. Right. So, but what do we mean by a rights-based approach? And I've tried to summarize this in four kind of sub-areas. Firstly, that social protection, which includes in social assistance, should be considered as an entitlement, as a right that can be claimed, and not merely as a charity. And that's quite a mind shift that has to take and had to take place for many countries in Africa in particular to realize this. But increasingly we see this being done. Secondly, from the perspective of the state, that the state or government then would have an obligation to recognize and to guarantee social protection. Also new for many countries in Africa, but there is an increasing realization, take up of this, as you will see in the instruments. Thirdly, that in measuring or assessing compliance with this, we see that there are certain core obligations and minimum standards which we should expect to be in place, and we'll actually see what Africa is doing for the moment, especially at the level of its continental instruments to give effect to this very principle. We'll come back to that. And finally, but very importantly, that mechanism should exist to hold those who design and deliver social protection accountable. We do not have time to delve into that last area in absolute detail, but we see all kind of accountability measures and mechanisms taking shape, even in the area of social accountability. Can we go to the next slide, please? So now we look at the constitutional picture that we see in Africa. But before we talk about the constitutional picture, broadly speaking about legal frameworks, which a constitution is part, would normally be guided by policies, strategies. The publication or the report referred to actually highlights the amazing extent to which social protection policies in Africa have taken root, in particular in the last, I think since 2006 in particular, an absolute mushrooming of the policy framework. And that would then inform the legal context as well. So what then is the value of a legal framework? There's much to say about it, but in short, it brings about clarity for the citizens, for those who are users or the potential users of the social assistance system, to know exactly what their benefits are, the procedures to be followed, the entitlement criteria, etc. But simultaneously and quite importantly, a legal framework serves as a formal mandate for the state and for other actors to act in a particular way. A very important area in law that the state must have the mandate when they act in this regard. Now, interestingly, the next issue here refers to the recognition of what we could call a right to social security, sometimes referred to as social protection or welfare or right to existence. We find in no less than 19 countries of the continent, 19 of the 54 countries, that somehow a right to this is being officially recognized. And again, much of this has come about in the last 15, 20 years. The picture was very, very different 2 decades ago. South Africa, Kenya, Comoros, examples. Focus also on a variety of vulnerable groups in the Constitution, as you will see from one of the tables or figures we'll be using. And very often we find in the constitutions then, especially where the right is embedded, that a mandate, or if not an obligation, is given to the legislator to adopt legislation to give effect to the constitutional rights. The Kenyan Constitution, South African Constitution, I think, are examples. The next slide, please. And this brings us then to a kind of a figure as to, or a picture rather, of how social protection is reflected in African constitutions according to the regions. And the green part, or the green part of the bars, I mean, it's clear the picture that all over Africa, the majority of countries, 44 out of the 54 in total, recognize social protection, not necessarily as a right in the Constitution, but at least refer to this in the Constitution. As I said, as far as the right to social protection in whatever form is concerned, we find this in 19 of the constitutions. So quite remarkable, bearing in mind where Africa came from. The next slide. The next slide depicts for us the extent to which the constitutions reflect on vulnerable groups, mention them, prioritize them, and quite a high number of constitutions would do this in relation to women or families, the elderly, children, youth, persons with disabilities. All 4 of those, more than 40 out of the 45 countries. And then there are some other groups like sometimes migrants or refugees, etc. mentioned. The next slide, please. And a good example of a constitutional approach and the approach, the take that the judiciary would have on this would come from the South African case. Now I'm quoting for you from one of the seminal constitutional court cases in South Africa, dealing in fact with the right of migrants who are permanent residents to social assistance in Africa, where this was in fact recognized. The court said, and I'm quoting, "A society had to attempt to ensure that the basic necessities of life were accessible to all if it was to be a society in which human dignity, freedom, and equality were foundational. The right of access to social security, including social assistance for those unable to support themselves and their dependents, was entrenched because society in the RSA valued human beings and wanted to ensure that people were afforded their basic needs," unquote. We can move to the next slide. Very briefly, bearing in mind our time, the national social assistance laws, we see an increasing enactment of social assistance laws, but different modalities and emphases apply. The Portuguese-speaking or Lusophone countries have a particular way where they would adopt a framework law and then later on come with the detailed regulatory pictures for in relation to, for example, social insurance, social assistance, etc. National social assistance law would emphasize also in-kind benefits and social services, or increasingly, slowly but increasingly, universal approaches, universal health care, for example, vulnerable groups focus, life cycle approaches, and more recently in Mauritius, so 2016 law, social integration and empowerment. So you see the interesting kaleidoscope, so to say, of approaches adopted by countries. Next slide, please, in the social assistance laws. So what about our regional and continental instruments at the regional, sub-regional level? EAC, ECOWAS, SADC, just one example, the SADC Code on Social Security, which would actually then recognize the right to social assistance. At the AU level, very interesting, we have the Banjul Charter, the main or the key foundational document in Africa for human rights. Although social security, even in social assistance, would not be explicitly mentioned in the Banjul Charter, this has been, the Charter and the rights in the Charter have been interpreted to imply as a derivative right, the right to social security, as you can see there. But please note what the African Commission on Human and People's Rights has been saying, that it ensures access to a social security scheme that provides a minimum essential level of benefits to all individuals and families. This is an important point, minimum essential level. Next slide. Because that idea of a minimum package or a minimum essential level is actually replicated in several other, many of them recent African continental documents. The idea, it goes back, for example, to the Social Policy Framework for Africa, and also the most recent draft AU Protocol on the Rights of Citizens to Social Protection and Social Security. And I must say that this idea of the minimum package actually predates the social protection floors idea that we all are so aware of. Next slide. Next slide, please. So what are our conclusions then? So are these constitutional guarantees, are they enforceable? It depends. It depends on on the status, if I could use the word, being given to constitutional guarantees, the nature of the guarantees. In some countries, like in Zambia, for example, Tanzania, they are viewed as directives, for example, directives of state principles, and that part of the constitution, not necessarily directly enforceable. They can be enforceable in the indirect sense. Other countries like Kenya and South Africa, clearly they are directly enforceable, and they are indeed enforced by the courts. But also the effect of the availability, of effective judicial mechanisms, of efficient remedies, and appropriate access to these mechanisms. All of these play a very important role in our appreciation of as to whether constitutional guarantees are really able to to provide this human rights edifice for social assistance in Africa. Generally speaking, we see an increasing reflection of that. National laws are often gradually adopted. They increasingly link monetary social assistance benefits to other benefits and services. So this has become a hallmark of recent social assistance legal reforms. Then our final slide, please. Next one. So the value of international, continental, and regional instruments, they depend on a number of factors. Ratification as a first point, not that countries only follow ratified instruments, but it is important. And what we see here is a very interesting tendency in Africa, that there's a large-scale ratification of AU and UN instruments, but not so to the ILO, and if I could use the word ILO, technical instruments on social security or social protection. Are these international instruments and these embedded standards, are they translated into national legal frameworks? My impression is, from the reading I've done of the constitutions and national laws, that increasingly that is the case. African countries are being serious about trying to give effect to the international standards, even if it's not directly binding on them, if they haven't ratified, for example. And then important, the issue of effectiveness of the reporting obligations, because these reporting obligations would also give an opportunity to other parties, not just government, to reflect on what the countries have done, referring to non-state actors, for example. So our overall conclusion is that there is clear evidence of an increasing recognition in Africa of social assistance as a human right expressed in a rights-based approach. However, much more needs to be done. And I think the continent needs to be commended for that. So thank you so much from my side.
Okay, thank you very much, Marius, for your contribution. I think it was very interesting to hear the value of legal frameworks in terms of providing clarity for citizens, but also providing clear mandates for government institutions. I think I will hand over now to David to share with us his presentation.
Thanks so much, Liya. Hopefully you hear me well and you see the screen appropriately. And thanks also, Marius, for that really fantastic presentation. Let me start by saying that the title of this isn't really quite right. It says Legal Frameworks and Social Transfers. Really, the focus is on the role that legal frameworks have played in the COVID response. So in that way, I think it follows very nicely from Marius's presentation. I wanted to start, let me just make sure the slide is clicking. Yes, just quickly to situate legal frameworks within UNICEF's work. So here you see UNICEF's new Global Social Protection Framework, which is very recently out. Do have a look at it if you're not aware. And you can see on the right-hand side the sort of circle of evidence, policy, program, and admin, which drives how we see child-sensitive social protection systems. And policies isn't quite right at the center. It used to be right at the center, but we really felt an evidence base is essential to build out to policies, programs, and admin. But it's very, very much at the heart of what we do in UNICEF. And again, the social protection framework breaks out 10 action areas of UNICEF's work. And we work in over 100 countries. There's an enormous amount of work going on in different places and in different areas. Legal frameworks, policy, and financing for social protection are really at the heart of a lot of what we do. So it's a really core piece of what we try and support governments in doing. But I thought it would also just be useful to share some of the principles behind UNICEF's approach to social protection, because even though our work is very diverse, what drives us, the center that takes us forward, is really pretty solid and clear. So we're a rights-based organization and work for rights-based social protection. We focus on the progressive realization of universal coverage. We work on national systems and leadership, not UNICEF-driven programs, and also focused on inclusive social protection, really reaching the people, the groups that are most likely to be excluded, to make sure that they're included within the system. So that's just a word on where UNICEF comes from, where I come from. But now I just want to transition into this question of COVID. So let's start, first of all, by looking at the impacts of COVID. There are lots of projections out there. I'll show one in a moment, but I think it's also useful just to remember the starting point that we're coming from. We, of course, in UNICEF look at children, but that also includes children and families. And what this shows are the rates of people living in extreme poverty by age. And you can see here the children in the first red box, 0 to 4, 5 to 9, 10 to 14, 15 to 17. Children are essentially twice as likely to live in poverty as adults. And it means when COVID comes, they're at particular risk of the economic consequences that COVID is bringing, both immediately and in the longer term. So there's a real concern there that children will be really seriously affected. And of course, we know when children experience poverty, it can be really have lifelong impacts on them, with implications for societies and economies more broadly. So the challenge is big. When we look into the projections of where we might be going in the future, the severity comes out even more strongly. The biggest economic impact since the Great Recession. Sub-Saharan Africa is expected to have the first recession in 25 years, with growth at -5% in 2020. And recent analysis we did suggested that there are 86 million additional children who are going to be falling into poverty by the end of 2020, so a 15% rise. So the severity of what we're facing is extremely serious. So what role might legal frameworks play, or should legal frameworks play, in the COVID response? And here I just put together a little schematic, because this is a somewhat complicated question, I think, or it was when I tried to think it through. So the ideal perhaps would be, if you had a strong legal framework, that then creates and helps build a strong and shock responsive social protection system. And that then leads to more effective COVID response and recovery. So that would be the pathway we'd be hoping to see. And it's not an easy question to investigate empirically, but I've tried to give some thinking around it in the following slides. Again, just to think about the starting point for the response, only 35% of children globally receive any form of child or family benefit. And in Africa, the number is as low as 16%. So it's a challenging starting point in which to scale up. And I think this also hints to a point Marius was making in the end of his presentation about legal coverage not always being translated into effective coverage, which creates a very, a harder environment in which to scale up. So this is the response, and it has been really, really impressive. In many ways. So since the 20th of March, it's built up to 190 countries having some form of social protection response, overall 937 programs. They vary in scale and scope. Most of them tend to be shorter term in nature, relatively generous, following what normal existing transfers are, but it really does show a very significant scale up. And the source of this, which Marius was using as well, is a great source if you're not aware of it. Gentilini and Dale and others, World Bank and UNICEF, putting these numbers together in a very updated way. And in fact, tomorrow there'll be a new update. So it's a phenomenal resource. So in terms of the scale up, again, what role is the legal foundation making in the COVID response? The analysis of this paper breaks down the adjustments into 3 different areas. So horizontal expansion, which is reaching more people than you're currently reaching with your current program. Vertical expansion, so to increase the amount of transfers people are receiving. And administrative changes, which allow, say, conditionalities to be dropped, time of payment to be changed, sorts of things that make it easier and more effective for people to be paid. And in this, on the right-hand side, you see this sort of little bubble of how many are doing which of what, if you see. Given time, I think I won't go into that. So one of the pieces that the analysis I think is interesting is to try and see, because I mean, I guess the question is, with these forms of adjustment, is it going to be programs that are legally founded, have strong legal foundations, which are going to be more effective at being able to show these adjustments? And again, it's a difficult thing to pull apart, but there's some data that was put together, which I think is interesting, gives an interesting indication. So what this slide looks at is the use of new versus existing programs in the COVID response. So on the left-hand side, you see in the orange and the blue, a total of 283 programs are responding in terms of social transfer, social assistance to the COVID epidemic. 122 of those are existing programs that are being scaled. 161 are new programs, so new discretionary programs which are reacting to the crisis. On the right-hand side in the green, here you see the same data but by countries. So currently only 20 countries are using solely their existing programs and not new programs. And there are 104 that are using at least some new programs. They may also be using old programs. So this is interesting. I mean, this is sort of a proxy. It's not easy to directly interpret, but I think what it shows is there's an awful lot of new programs being used in response, which implies that current programs are not quite able, in all cases, to be the vehicle for response. So from this, I think one can imagine 2 different pathways of how a legal framework can translate. Just excuse me for a second. In how a legal framework can translate into a more effective COVID response. So you can have a strong legal framework. If you have that in place, that can be translated in actuality into a strong social protection system that is shock responsive, something which can be scaled up and used effectively in terms of responding in a situation like this, which would lead to a more effective shock response and recovery. On the other hand, a strong legal framework may not be converted into sort of the actuality of a strong program that is able to adjust and flex, and then therefore the social protection system will be less able to respond, and additional discretionary programs would be needed. So it's this middle bar which becomes very interesting, this translation. What does it look like to have a shock responsive social protection system, and what should be included within legal frameworks? So in UNICEF, we've done quite a lot of work looking into this with our country offices in terms of what makes a social protection system ready to respond to COVID or indeed to other shocks. And we looked at this through 2 lenses. One, which is this slide, is system readiness. The next slide looks at more of the policy framework and coordination environment. The numbers you see here, this was a survey done with UNICEF experts. I won't be showing any country names on this. It's very much sort of an internal piece of work, but it I think reveals interesting information. So the numbers relate to how many countries. There's a total of about 52, I think, responded positively. So in terms of system readiness, what are some of the things that you'd want to look at to know that a system is effectively going to be able to respond? And here there are, a core is that the country has a national cash transfer program, and the larger it is, the more people it reaches, the more effective it's going to be and able to scale up. Similarly, to have a management information system, a case management database, if you want to do more direct work to be in touch with beneficiaries. And you can see here a range, I won't go through all of them, the sorts of things that you could look for in a system that would help shock response be able to be integrated well within the system. And from our sample, you can see a range of which countries have different pieces. In terms of national policies and coordination, here we were looking at the broad policy framework. So it's not directly linked to legislation, although there are elements of it which are connected. And the questions we wanted to understand is there an active disaster management plan? Was cash included in that plan? Because if so, a country will be able to respond if these things are embedded within existing policies and frameworks. Does the social protection strategy include emergency response? Some countries had a national policy on humanitarian cash transfers. And we're also interested in the history of social protection and emergency authorities working together in emergency response. So these pieces give a sense of what a ready system could look like. And here is just a way of summarizing that information. So this is essentially organized by country. Again, I'm not showing the country names because it's quite internal information. But you can see with the greens which are the countries that have the pieces in place which would lead to a system being able to respond effectively to shocks. So then the question in terms of legal frameworks is, if you have a strong and appropriate legal framework, you would be better placed to be able to have these pieces in place in order to be able to respond. But they need to be included. The system, the legal frameworks need to have them included, particularly at sort of policy and strategy level. So for that crisis response to be there, what's needed within the system are aspects such as high effective coverage of programs, as I mentioned, policies that recognize horizontal and vertical expansion and flexibility of implementation, so that that's already codified in, that those changes can happen quite rapidly. And there are examples of countries I've heard from colleagues where it actually becomes inflexible, the legal framework, and that can become harder and you need separate decrees to make the change. Coordination between social protection and emergency response, comprehensive management information and digital systems, operations manuals and trained staff ready for a crisis, and inclusion of non-citizens, migrants and refugees, because very often, it may be less so with COVID right now, but very often in crisis, the movement of people becomes essential and the ability to connect them to systems. So if a legal framework can have these foundations, it can be incredibly effective in allowing countries to respond. And pulling from a few examples of countries that have had a very strong response and do have a strong legal foundation of their work, you can see how this can work in practice. So for example, in Mongolia, the Child Money Program scaled up 5 times to 6 months, and that program was legally established, it's in place, it's ready to move. It allows the COVID response to happen very quickly. In South Africa, for example, top up to the child grants and other programs are reaching 12.8 million, and it's because there is this strong established program in place. And I think one thing that comes through very strongly, but I don't think I've put in the slides explicitly or said explicitly, is that legal foundation is what allows programs to grow to become the big, strong, comprehensive programs that can respond. And that's why you see with these big programs there is a legal foundation behind it. Finally, or almost finally, I just wanted to say that, well, 2 things, that responses can be effective even without a strong framework, and that strong responses without a framework can actually reverse the course and lead to stronger legal responses. So if we look at the 104 countries that are using new programs, many of these programs may be effective as a discretionary response to COVID. And they begin a process of understanding and developing responsive programs and systems, which can then inform the policy conversation in terms of really highlighting and outlining the right to social protection, the ability of a system to be able to flex and respond and scale up when it's needed, or indeed move towards universality, which makes a system much stronger. So that's almost it. This is my final slide. I just wanted to say a couple of things. One is that I'm focused here on the response and recovery, but of course, legal frameworks are essential to fulfill the right for social protection. But also, I think it's important that we always keep our mind on the shocks that are to come. And this slide is simply showing one poverty scenario impact of climate change and the poverty changes that will result from it. As we know from everyone's perspectives, but it's for no one more important than children in the next generation, the climate impacts that are to come. And I think as we learn from COVID, as we see this really positive social protection response, let's keep in mind these challenges which are coming up. So that's it from me, Liya. I will pass back to you.
Okay. Thank you very much, David, for this great presentation. I think it was really interesting what you're saying, that on the one hand, legal frameworks could strengthen shock responsiveness of systems, but could also slow them down. And to be effective, legal frameworks need to include aspects that facilitate system readiness, shock responsiveness, coordination, and also be open to inclusion of non-citizens. I think that's an interesting takeaway that can also inform our work towards increasing rights-based social protection. So thank you very much. And I think it's a great point to hand over to Sarah, who will talk to us more on human rights-based approach to social assistance or social protection. Thank you.
Thank you so much. I hope everyone can hear me well. It's a real privilege to be joining you today on this webinar. My name is Rattray, and I am one of the colleagues in UNDP working to provide programme and policy advice on human rights specifically. One of the reasons I'm so delighted to join this discussion today is really because the report itself, which the webinar is focusing on, the Social Assistance in Africa report from 2019, is really groundbreaking in looking at the field of social assistance, including social protection on the continent and the links to human rights, and of course the discourse on the legal frameworks and these important perspectives. So it's great to be with you. I have a few slides, but I think I'll be able to skip over some elements because there has been already some important insights shared from the previous presenters, and thank you also to them for their insights, which are so helpful. What I really wanted to do, and if you can go to the next slide, please, was focused on 3 points. Really touch on what the relationship is between the legal frameworks and the human rights framework for social assistance. Why is the human rights-based approach so important to realise social assistance? And then talk a little bit about some of the relevance of that today in the context of coronavirus, but then also looking at some examples and some tools and resources that are out there and can be helpful to us as a community supporting the right to social protection and social assistance, both from the UN side and then also from academia and partners, and how we can use these opportunities. If we can go to the next slide, please. Yeah. I think, as Marius emphasised, there is already quite a strong element of uptake of international treaty obligations on the continent, and the elements of the relationship between legal frameworks and the human rights framework are quite clear in the report itself. I don't want to repeat them. In fact, the report does, however, highlight that some of the legal frameworks related to social assistance on the continent actually predate the advent of the modern human rights framework as we know it today, which was really birthed through the Universal Declaration of Human Rights and the subsequent normative standards, as we now refer to them, which is the treaty bodies and the treaties that member states voluntarily sign up to. However, only looking at legal frameworks without looking at the incorporation of human rights and the content of the legal frameworks is not a necessary enough evaluation. The human rights framework itself provides a broader relevance for the discourse on legal frameworks and development more generally. And it does this by reinforcing a number of critical aspects to the discussion. Firstly, it really puts the rights of people to certain inalienable rights inherent in the Universal Declaration and in other treaties at the centre of the discussion. It puts dignity at the centre of the discussion, and includes other critical enablers. It really emphasises them, such as non-discrimination, which I'll go on to talk about more, the importance of that in our discourse and in our responses. Specific treaties also expand on key elements. I think 7 of the 9 normative treaties make specific reference to social assistance or social protection, social security, including, of course, the International Covenant on Economic, Social and Cultural Rights. But then there's also specific provisions in CEDAW, for instance, and in the Convention on the Rights of Persons with Disabilities, and in other frameworks. It's very important when we consider these frameworks that we really take into account the accountability aspects of it. The Universal Declaration is customary international law, but the treaties which make up the bulk of the normative framework are obligations that states have voluntarily signed up to. As a consequence of this, they've pledged to take specific actions towards a human rights culture and vision in their societies. And this is manifested in their individual legal frameworks in different ways, or it should be it constitutions or other laws and policies. In some respects, there can be a misunderstanding around the universality of some of these rights. For civil and political rights, states commit to immediately take steps to be in full compliance with their obligations, for example, to stop torture or ensure the right to vote. But there can be a misunderstanding in relation to some elements of social and economic rights. These commitments are made by member states to progressively realise over time, recognising that there can be resource restraints. However, it's very important to note that this does not mean that there is a tipping point where, due to economic development, these rights should be supported by a government. Rather, it emphasises the principle of continual progress toward the realisation of rights. And no matter what the level of resources are at the disposal of states, immediate steps need to be taken towards the fulfilment of these rights, especially in relation to non-discrimination, which can often exist towards certain populations. Importantly also, I think Marius mentioned initially, there's core minimum obligations, and there's certainly an obligation to ensure that there's non-regression in achievement of rights. This includes acts which deprive people of rights that they used to enjoy. And this is an important point, as evidence has shown that when budget policy decisions are made in times of austerity, it's programmes and provisions towards social protection that can be most often affected. Another important element is accountability. As Marius mentioned, when states become parties to these treaties, they benefit from the expertise of treaty bodies and special procedures of the human rights mechanisms. And they're also overtly making these rights part and parcel of their social contract with their citizens. One important element that I think often isn't emphasised as much as it should be is that by states joining and signing up for this global vision, by becoming states parties and the obligations that they have, there's really a strong element of technical cooperation and peer-to-peer support between states. There's regional mechanisms, including in Africa, to do so. And these legal frameworks within different regions differ. But mechanisms such as the Human Rights Council's Universal Periodic Review process, where 100% of member states have their human rights records reviewed by their peers and accept recommendations, can be really important opportunities for solidarity and technical cooperation between states. And lastly, just very briefly, another important point is that as we're all trying to support the achievement of governments to progress toward the Sustainable Development Goals, it's important to always remember the strong complementarity between the SDGs and human rights. 92% of the SDG goals and targets directly correlate to human rights obligations of states. So these are highly complementary frameworks, and supporting countries to realise their human rights will also support achievement of the SDGs more broadly. Can I go to the next slide, please? We know that the normative human rights framework provides this vision for the key elements of social protection, and we've seen a variety of legal frameworks presented by the previous speakers. Many of them aspire to or do meet the standards of social protection as they're outlined in the framework, but some do not, and that's emphasised in the report. Legal frameworks, if they're not rights-based, can unfortunately end up not only not advancing human rights, but in the worst instances, they can reinforce discrimination, whether overtly in laws or in practices. So the human rights-based approach, I don't want to repeat the elements that Marius mentioned, but I want to expand on some that have not been referenced previously. It really has two specific aspects. One is certainly that the content of a rights-based law or a rights-based legal framework in relation to social protection would meet the standards which are those inherent in the normative framework that states have signed up to and it's enshrined in the Universal Declaration. And this is further elaborated on by outputs of the human rights mechanisms, such as the treaty bodies and recommendations to states through the UPR. But in addition to the standards themselves, there are very important principles at play in relation to the human rights-based approach. And these include non-discrimination, they include meaningful participation, and they include accountability. So on those principles, really, ensuring non-discrimination is so critical in relation to their access to social assistance. And meaningful participation also is tremendously important because it really aims to dismantle discriminatory approaches that may be overt in legal frameworks or implicit in those frameworks. And that can only really be achieved through the meaningful participation of all actors engaged in a process. I think this is particularly relevant in relation to social protection because so much of the assistance is informal in the continent, and it's really necessary to ensure that meaningful participation. This isn't necessarily groundbreaking in terms of development approaches. Meaningful participation is something that's recognised as critical in development, and many may assume that's the same case with non-discrimination, but our experience is that you have to make this a specific intent and objective in frameworks and in support to be able to realise and address it correctly. One shouldn't assume that that's a byproduct of a rights-based legal framework. But I really want to emphasise the issue of accountability because this is where the HRBA is really unique in terms of these approaches. Because the critical element is that progressively realising rights is a legal obligation of the state. So the consequence of that is that there must be a means for the state to be held accountable through redress and other mechanisms. The previous speakers mentioned justiciability and the groundbreaking jurisprudence on the continent, the South African cases specifically, but there's other ways in which this is happening, including strengthening oversight and other bodies. Examples of this are national human rights institutions, but there's many more. And this changes the nature of the support from benevolent charitable approaches to rights of populations, groups and individuals. And that is the really significant shift when we speak about the human rights-based approach. And if it's supported, it can also strengthen the relationship between the state and populations and ultimately the social contract. The sensitivity around that, of course, is that doing this well will really mean that we have to look very closely at power imbalances within societies and within communities, and we have to attempt to address them and even dismantle them. Unpacking power dynamics, supporting a greater engagement and understanding this relationship between duty bearers of the state essentially and rights holders is really critical to really fundamentally address issues around the responsibilities at place, motivations, commitment, political leadership for change, access to and control over resources, and then also authority to take action. And all of that is necessary for real and sustainable change in this area. This slide includes, on the right-hand side, I'm not going to go into it now because of the sake of time, but it includes the analytical approach that's been developed and is a common understanding within the UN system to be able to look at the gaps and capacities of duty bearers to meet their obligations and the gaps and capacities of populations in order to claim their rights, and then to really have an analysis of laws, policies, and mechanisms for redress, and then essentially through looking at those capacity gaps to be able to take development approaches that seek to support those gaps being filled. I'm not going to go more into that right now. I hope there's great familiarity with this process. Moving on to the last slide, just for the last couple of minutes. I'd really wanted to just reflect a bit on the kind of practical applications of this, because I know that this might in some respects sound quite theoretical, but excuse me. I think when answering the question about the relevance of these approaches today, it's really important, of course, that we're cognizant, as the previous speaker emphasised so well, of the challenges in relation to COVID-19 and how that's presenting risks to human rights, to the right to social security, protection, assistance. We know from the data available that globally, in the context of COVID-19, there's a disproportionate impact on populations and groups that were already facing challenges of inequality and barriers to realisation of their rights in societies. So strengthening accountability, oversight mechanisms to ensure rights-based responses to the pandemic, and monitoring the impact of the pandemic as it affects populations and services remains really critical. Aside from the jurisprudence elements that I think have already been mentioned, I wanted to just give an example of how some of these oversight bodies are supporting the right to social security on the continent in the COVID context. One such is national human rights institutions, which UNDP has worked in over 100 countries globally. There's a number of these bodies that are functional in the African continent, and these are independent state bodies charged with promoting and protecting human rights. And when they work in compliance with standards, they're really critical pillars of the architecture at country level. In Sierra Leone, for instance, UNDP is working with the Commission to ensure a rights-based response to COVID in a number of ways, including hearing complaints on violations, public awareness, monitoring, and strategic engagement. And this is included with national commissions for social security action, reviewing social protection provision for persons with disabilities, for instance, who are a highly at-risk group in relation to COVID, ensuring support for the Ministry of Welfare and those of needs and social assistance and quarantine, and so on and so forth. I only have a moment left, so I'll just quickly rush through a few other examples. You know, another way in which we can really ensure social protection and the strong link between human rights mechanisms and human rights approaches at country level is ensuring social protection remains central to these efforts to strengthen national human rights systems. And there's lots of ways this happens in different countries. Some are developing national human rights action plans. Some are really looking again at the Universal Periodic Review process, where all states, every African nation participates at the Human Rights Council, and looking at how they can follow up on the recommendations received and linking it very much to the Sustainable Development Goals. I think that's an important way that we can also reinforce and re-emphasise and keep social protection at the centre of these discussions. Lastly, I just want to emphasise that there's a great deal of guidance available in this area from some of the special procedures of the Human Rights Council on social protection, on different elements of social assistance, including housing, including rights to health, the discussion on universal health coverage, on specific areas in relation to disabilities, and so on and so forth. And really trying to engage more systematically with that technical guidance and support that can come through these mechanisms can be very helpful at country level. And it can really help to promote what is really necessary in terms of a strong human rights culture. And that also goes, of course, to supporting human rights in civil society. So I'll end here just by thanking you for letting me take the floor and to reiterate the importance of this report in itself and these linkages with human rights frameworks and mechanisms. And really to emphasize that these are complementary frameworks to help achieve social protection. Thank you.
Okay, thank you very much, Sarah, for this great presentation, also sharing some practical resources on how to actualize a human rights-based approach. I think it was also an important message to share that legal frameworks that aren't intentionally human rights-based can actually be harmful. So it's important that human rights-based approach is intentionally pursued and centered. With this, thank you to all three presenters. I think there are some interesting takeaways from all the presentations. Something that we also highlighted in the report is that there's an increasing recognition of social protection as a right, which is reflected in all the new policies and legal frameworks that are coming up, as Marius showed us. Of course, the realization of the right of social protection depends on the ability of governments to enforce legal instruments and also the ability of people to hold the government accountable, as Sarah has shared with us. I think it was also interesting to learn that for legal frameworks to be effective and in their contribution to the COVID-19 response, it is important that these aspects of shock responsiveness are embedded in the legal framework. Yes, and I think another important takeaway for me is also that to ensure a human rights-based approach to social protection, it is important that we also progress meaningful participation of all stakeholders, and that it's important that there are accountability mechanisms and active commitment to non-discrimination and rule of law. With this said, we've had some questions come in, and yeah, I'd like to move on to the Q&A session. 1 second. So the first question is to Marius by Gabriel Fernandez. Gabriel is asking, thank you for your good presentation. However, I did not see any mention of financing of social protection as part of legislation. Gabriel asks, isn't it important to ensure financing of social assistance and social security is legislated to ensure appropriate annual budgetary allocation, including additional financing during a crisis, to include additional beneficiaries impacted from the crisis, by the crisis? So his question is, should aspects or on financing of social assistance be included in legislation? What is your opinion?
Yeah, thank you, Gabriel. It is, of course, a very difficult question. Remember where we come from. We come from a scenario where initially social assistance was all kind of program-based, discretionary-based, as I've said. So it's already quite a huge turnaround for governments to have allowed legislation to provide for social assistance, even in a rights-based framework. I must say my reading of most of the social assistance laws on the continent is that very few of them explicitly provide for the financing aspect. A few do, especially where separate mechanisms have been set up to administer and social assistance, right? Such as the South African Social Security Agency, SASSA. So its separate law, of course, has the financial dimension as well. I'm not so sure that and by the way, the reason why I didn't cover this in the presentation, just because of time reasons, I'm not so sure that we really always need the the financing element to be fully explored in the legislation. And if so, even if you do that, the question is, how far can you go? If you already guarantee the right to social assistance, number one, if you then indicate that right implies, for example, there's a child grant, there's a disability grant, etc., then the values that you attach to those grants, of course, those values are determined from time to time. They may increase every year, every 2 years. So how far can you go with legislating this? But the mere fact that the right as such is already entrenched in the legislation gives some kind of basis or formula, so to say, for beneficiaries or applicants to rely on. And we have seen this vividly, at least in the South African case, where government would be taken up in terms of its non-provision, for example. But to force government to make available a particular amount, that's very difficult, and I don't think the continent has gone that far. I'm not even so sure that in the other countries in the world have gone that far. But we have to remember two things. The one is that what happens in practice, of course, is I think, in my view, is very clear. We see that all over the continent is that countries, especially where there is such a legal framework, would then automatically include in their annual budgets allocations for social assistance. They would do it in different ways, different kind of headings that they give for this, but normally it could be in the framework of a social protection part of the budget, or social budgeting more broadly. And I must say, those of us who work in the area would know very well that there are several organizations, including the ILO, that actually assist government with developing this. and even doing some actuarial work for and with government. So the picture on the ground is not as gloomy as it may seem, even if you were to accept that there's no proper legal basis. My second remark is that, you know, for countries with a constitutional framework, I think of countries like Kenya and South Africa, where you have the provision which says, and I'm quoting, that this right, including the right to access to social assistance, must be realized progressively, etc., etc. But then it says within the available resources. Now it's a bit different from what the you know, the UN International Covenant on Economic, Social, and Cultural Rights would phrase it, but within the available resources. And at least in the South African context, this has played a powerful role to keep government accountable for even rolling out social assistance. The Xhosa case that I quoted from actually was a case in point, where the Constitutional Court asked the South African government, but, you know, what are the figures and what do you base the figures for not making available these social assistance grants to permanent residents? And the court said, well, whatever figure you quote to us, several figures were quoted, the court said, well, it does not weigh up against the seriousness of the infringement of the fundamental rights in question. So along that route, you could achieve that purpose as well. So yeah, I think for the moment that's all I need to say. Thank you.
Okay, thank you, Marius. Let me move on to the next question, which I will address to David. So it says, sorry, the next question will be to Sarah. Sarah, could you comment on the role of civil society to advocate for a human rights-based approach to social assistance? How can this be supported by international organizations such as UNDP and UNICEF? If any others of you also want to come in answering this, please feel free.
Yeah, thank you so much. And that's a great question, particularly because the national landscape is so different from country to country. Some countries may have different state institutions or independent bodies or commissions that have a particular standing to monitor the human rights system, for instance, national human rights institutions, but there's a number of countries, of course, that won't have those bodies. And in either case, the role of civil society is very critical, particularly also because they can play a very fundamental role representing those who are the most underrepresented in societies, those who do not necessarily have a voice at the table in terms of our development support or in terms of engaging with policymakers. They should, of course, and that's always something we're aiming to achieve, that civil society actors can represent very underrepresented groups. And the UN system, and certainly UNDP, is a fundamental tenet of our programming to ensure participation of civil society in our development interventions, be that in our planning and design phases of our programming. But what is really important actually as well in relation to civil society participation for social assistance and protection is on the monitoring of the impact of the assistance that we're providing. And very often there's participation of certain groups or civil society or actors in the conceptualization phase of development interventions. That's critical, of course. We would certainly shouldn't proceed without doing that. But I think another and equally critical aspect is their engagement in terms of the monitoring of the assistance that's being provided, because that should also be systematic and should be part of our general approach. And I mean, there's many examples of UNDP's engagement with society. I'm sure UNICEF has many as well. I mean, we have some global partners that we deal with at global levels, and then of course in the regional context, there's regional partners. And then in country level, there's also, you know, national partners. So I think it depends on each and every national landscape. But I would mention, for instance, just as one potential group that's been specifically highlighted quite clearly in relation to social protection and COVID response on the continent is persons with disabilities. There are, of course, national associations and civil society groups of persons with disabilities in many countries. In Africa, UNDP supported the first regional body of that kind on the continent, the Africa Disability Forum, and is supporting their efforts to establish national chapters of disability organisations in countries in order for them to, of course, highlight and advocate for persons with disabilities in rights-based processes and government policy and all aspects of public life, but also very much for them to be able to engage in demonstrating the needs, the situation on the ground, the potential for change, the types of interventions that would work and would not work. And that's just one example of how we're doing that. I know there's a number of people, participants on the chat from various countries I recognise who are engaged with this important work. We're also working very much with many women's organisations and civil society groups, and again, I think in each national context that's critical. But one thing I would caution on this issue though is that as development actors, we also need to really look behind the most obvious players that can sometimes be very prevalent at national level. The issue of power imbalances that I mentioned in my presentation is also, or can also be, an issue in relation to civil society. And we need to look beyond the sort of the biggest and most highly represented organisations and capitals and really be able to look at populations that are facing discrimination and ensure that their voice is central to our discussions. So I would mention that, and I'll stop here. Thank you.
Could I come on this as well? Thank you so much, Sarah. This is great. I think there are a few additional perspectives. If you look at it from a national level, but even from a regional continental level, we are seeing increasingly in several African countries a role being picked up by civil society, non-state actors in this area. I see this in Kenya, partly in Ghana, certainly in South Africa. The role civil society has played in expanding the whole social assistance framework in South Africa is just, I mean, it's second to none. It really is a story on its own. But also in the legal framework, I mean, they were mainly the drivers of, the court cases that were brought. And in fact, class actions, South African Constitution, as is the case with some other African constitutions, allow for class actions, and some of the breakthroughs that we have seen in expanding even legally the scope of social assistance in South Africa, that has come through the class actions. So a vivid civil society is extremely important, and it's a very valid question as to how can we support that role. But let me say two other things. The one is social accountability, which I briefly mentioned, is an area which has also taken root in many African countries. The last part of the legal chapter in the report that Liya referred to actually deals with that, so I'm not going to talk about detail now, but have a look. It mentions some of the things that Sarah referred to, the monitoring, but also grievance redressal, bringing the case for the beneficiaries and so on. And my final comment is that, we're not always aware or making use of the avenues that do exist. In some of the regional economic communities in Africa, not all of them, you actually have, of course, there could be restriction as to who can bring the case, but you can even use the regional adjudicative bodies, like regional courts. And from a continental perspective, there is the African Commission itself, the African Commission on Human and People's Rights, and it has jurisdiction. I mean, as I said earlier, social security is a derivative right. It's derived from the Untitled Charter. So there's no reason why even at that level, matters cannot be brought to the attention or for the determination by the Commission. Thank you.
Thank you very much, Sarah and Marius, for coming in here. The next question, which I'll comment on that. I'd like to comment on that, and also maybe Marius would like to comment. The question by Rebecca Waweru is many sub-Saharan African countries have pluralist legal systems. Customary law and practice may be preferred, and extended family and chiefs the primary sources of social assistance measures rather than the state, particularly when the state is weak or in conflict-affected context. Is there research available on these non-state social assistance trends in Africa? Is the amount of social assistance dispersed through customary practices being quantified? How are the legal frameworks and state policies and programs interacting with customary systems? So I'd like to come back on this interesting question. Indeed, this is something we have been with our team at the Regional Service Center at UNDP, some questions we've been looking into. Well, while we defend a rights-based or we want a rights-based approach to social protection provision, which means that the government should provide social protection to citizens. This is what we're working towards. As you mentioned, in fact, with coverage of social protection systems in Africa being, I think, numbers around 17.8% people actually have access to social protection benefits. So it being very low, customary and non-state or community-based social protection systems do play a big role. And they provide protection to a lot of people that are left outside of the social protection system, of the state-run social protection system. So this is something we are looking into and interested in finding out more, because also there hasn't been too much studies on that. So this is what my comment. Maybe over to Marius if you have something that you'd like to comment.
Yeah, thank you, Liya. About the quantification, quantifying this, I'm not aware of, work that has been done in that regard. It will be very, very difficult to do that. But there is certainly a growing body of literature in Africa on what is happening in this area and the role that we could call this non-state social assistance. You could refer to this as informal forms of social protection, formal social welfare. Especially lately in the last 5 to 10 years, a lot has been written. Rebecca, you're welcome to email me afterwards, and I can, point you to some of the sources. But what do we see? We see that a few things. The one is that for the moment, there is very, very little interaction with the formal system. Countries, governments, legislators haven't done that. A few countries are trying to do this now, but it's kind of like a silo approach. It's like two silos running on their own. The second thing I want to say is that, if you were to look at the informal forms or the non-state forms as kindly on the one hand mutuality-based, and the other hand kinship-based, all over the continent, the kinship-based mechanisms are really having a hard time for all sorts of reasons. The family ties are weakening, etc., etc. Mutuality-based schemes have more promise, but we have to recognize this, that all of these informal schemes have limitations. I mean, they cannot really cover for the sizable covariant risks that people are very often exposed to, like medical risk, etc. So there are limitations. Yeah, they are important, and there's some great work recently done in this area by several very, very good studies that I've seen. Thank you.
Okay, thank you, Marius. And Rebecca, please reach out via email if you want more resources on this topic. The next question I'd like to address to David from Gabriel Fernandez. Gabriel says, many African countries, as pointed out by Marius, have policies and strategies on social protection. However, with regard to legislation on social protection, there is far less. How does UNICEF see its role in strengthening social protection and recovery of post-COVID-19 crisis to address the impact of increased child poverty from COVID-19? What key provisions will need to be included in any legislation?
Thanks, Liya. And if I may also respond to one or two of the other questions. Is that okay, that came? Because there's some very interesting ones there. So yeah, in terms of the COVID response, I mean, I think the thing that is going to be really clear for large numbers of people, but for kids, we're very aware of it, is that this is not only going to be an immediate shock, but it's going to be long-term. There's going to be long-term economic complications, and there's a real risk of retrenchment and fiscal contraction. And that's what we saw in a lot of countries after the 2008 financial crisis. So what is really going to be essential is to try and build out and strengthen the national programs that are the responses that are happening now, and establish them for the longer term. And I think the hopefulness is that this is a moment where people are seeing again the value of social protection. It happened after the financial crisis. People saw the value of social protection, and suddenly this is an issue which people are really seeing the value of. So I think we have to collectively, I mean, UNICEF is one partner among it, but we have to collectively really push that forward with the governments that we work with. And I think that translation into legal frameworks becomes very important, because I think sometimes, and there was another question I think about sequencing, which is a very interesting question. Sometimes we work on supporting building out the programs without this longer term process of getting involved in the legal framework. And I think that can have a logic to make the case and to push things forward. But clearly we need to be establishing really strong legal provision for the programs and for social protection overall to really establish it, to make sure that it can't move back and can't be retrenched. And if I may then also just quickly respond, because Fabio asked a really interesting question there, so I'll take the liberty now I've got the mic. He asked a question about whether, the temporary interventions which we're seeing doesn't necessarily mean that the system is not shock responsive. And I mean, I think there's a lot in your question, Fabio, and much I agree with. I mean, I think the first thing I'd say is, yeah, when I show the examples of countries that are responding with discretionary response, it doesn't necessarily mean that it's not a shock responsive system, but we have very little limited information right now of what's going on. And I think it's indicative. It helps you think through, well, how is it that the majority of programs are not going through, the majority of responses are not going through national responses? And I think there are a couple of really important pieces. I mean, you mentioned that a targeted program won't reach everybody, so you'll need additional programs. And I think right there is something that's really important, is that where you have legislation for a significant program with significant size, that's where you're able to see the program be able to scale up in terms of complete response. So I do think one needs to look at that aspect of it. And finally, just to say, in terms of the legislation, you're making the case that the legislation is better targeted, if I understood rightly, around emergency response and that flexibility, rather than particular programs or potentially the social protection legislation, because the emergency legislation may be separate. I mean, it comes to a little bit, I think, of what levels of legislation we're talking about. And I think following the social assistance report, which I thought laid out really nicely, where you're looking at policies and strategies as well, I do think at the social assistance level, you do want to have included within that aspect of the legal framework, the ability for programs to scale and to be able to move relatively quickly. But I'd certainly agree, a perfect response is not going to be one that only works through existing programs. It depends on the shock, and this shock has been overwhelming, so you're likely to see discretionary responses. Thanks, Liya, for that ability to keep going a little bit.
Thank you, David. That was great to also group some questions. Another question I would like to address to Sarah is the question, how can UPRs be more effective in strengthening legal frameworks on social protection, including its implementation?
Thank you very much. And I'll also abuse the floor by mentioning one other thing from another question. Yeah, I mean, the UPR, as I said, is, I think, one of the most critical engagement points on human rights at national level, because it really enjoys the full participation of all member states. It's not contingent upon which member state is a treaty body party, a state party to a particular treaty. It really is 100% participation. All states participate, and it's a review by peers, so other countries providing recommendations to other countries, which can be the basis as well for technical cooperation regionally and globally. If the Republic of, if one country essentially provides a recommendation to another country, it's usually because they have good experience in that particular area, and that can really be explored and reinforced. I mean, but prior to the presentation, I had a quick look at some of the most recent UPR recommendations in Africa in relation to social protection from the sessions in 2019. And, there's quite a lot of them, I think 27 or 28 for various countries, some multiple recommendations for the same country, of course, which again also reinforces that this is considered to be this can be a significant challenge if it's reinforced by lots of different countries in the process. One of the challenges sometimes with the UPR process is sometimes the recommendations can be quite generic to improve social protection systems, for instance, and that can often be a challenge in terms of where to start. But increasingly so, and if you look at the recommendations from last year, and I'm happy to share the list which you can find on the Universal Human Rights Index, which OHCHR facilitates for the UN system for beyond the UN system, you can search there. Increasingly, what you can see in the particular search is some really specific recommendations. So specific recommendations to the Gambia, for instance, that went through the UPR process last November on different aspects of the social protection strategies that they have. So one of the recommendations there was really specific to the National Strategy for Social Protection for Persons with Disabilities. So I appreciate that there can be some frustration with engagement with UPR recommendations if they're very generic, but I would say that increasingly they're becoming less generic. And even when they are generic, if there's a large number of recommendations on the same topic, I think that just reinforces the importance of that specific topic. And then it's a way to unpack with the government how they wish to take forward the pursuance of the recommendations, because the review itself is only one aspect and a very critical and important aspect. But what really I think is potentially even more important is, of course, what happens next. What does the government do to actually take action to address these challenges? And we've seen great engagement in the follow-up to the process, which has really, supported quite significant change in a number of areas, including sometimes very sensitive areas in relation to discrimination or corruption or other aspects, some of which have, of course, implications in relation to social assistance. So I think looking at the UPR, not just as an opportunity for sort of a review of the record from this compliance accountability perspective, which of course it is, by fellow member states, of course, not by the UN system, but looking at the UPR as an opportunity for technical cooperation after the process itself is the way to really be able to support change through the UPR process. So I do recommend that colleagues have a look at some of these instruments where you can really filter through the various human rights provisions per country and see which countries have recommended change, and some, I think increasingly, I think it might be too early to say definitively, but I do think there is a trend that the UPR recommendations are becoming more specific to specific national policies or specific legislative frameworks, rather than I think what we saw in the early days of the sort of general comments. So I hope that helps to answer that question. Sorry, one other quick element of that is sometimes a challenge can be prioritization, because there can be 150 UPR recommendations. So how does the government decide what is the first 10 things that they will do? Because it can be very challenging. I think when you actually do look at the recommendations themselves, they tend to group quite quickly into sort of 10 big issues. But the number of recommendations can be very high because there are many states interacting. So doing that kind of grouping of UPR recommendations and then linking it to other development processes and discussions around the SDGs, for instance, and what is the SDG plan? How does that look at social assistance, and then bringing the human rights element in from the UPR, for instance, is then where you also marry the kind of human rights aspects and the development aspects, and of course that has to be reflected in the overall legal and administrative frameworks. But I would certainly caution from sort of looking at the UPR as its own siloed exercise. In order for it to be effective, it needs to be integrated in national development planning, policies and legal frameworks. One other quick thing, since I have the floor and I won't be able to have it again most likely, is I mentioned very briefly in my presentation, and it's been mentioned by the other speakers, the issue of available resources for economic and social rights, which include many of the rights that we've been talking about today. I mean, the International Covenant on Economic, Social and Cultural Rights does specify maximum available resources in terms of its language. And that, of course, we've discussed that in the presentations and don't need to go over that again. But insofar as we're looking from the medium-term outlook about COVID response policies, I think the point that David made around austerity and the evidence that we have from austerity approaches in the financial crash in 2008 is very clear that there can be a real emphasis from budget holders to affect social protection policy and social protection programs in austerity responses. And that's something that we need to be very vigilant about to support governments to still be able to progressively realise those rights, because those populations that rely on social assistance and social protection are already so disproportionately impacted. And I think that needs to be the forefront of our medium and long-term response and support globally. Thank you.
Thank you, Sarah. We still have a couple of questions, but we're running out of time. I'll just post one last question to Marius, and the other questions we will address via email. So one question from Ruby Khan. Thank you for your presentation. Can you please elaborate on the timing and sequencing on legal frameworks and regulatory instruments with regards to social assistance systems? Should one precede the other? And what are the lessons learned on the continent? I think David has already touched upon that, but I wanted to pose that to Marius also, because this is something you've been talking about.
Yeah, you know, I don't think there's a magic bullet as to exactly how this should be done. The general tendency that I've seen in a continent, an African continent, is that normally countries would first venture into the area of developing a policy or a strategy framework, and once that is clear, then they would go to legislation and address the legislation to give effect to the policy, and increasingly then to embed into that a rights-based approach. That's a logical sequence that I am seeing, if that is the question. I'm not so sure, and I think that's to be supported. Countries first must figure out for themselves what is the direction they want to take, and for that you need a policy framework. Of course, this can all be influenced very heavily so by constitutional imperatives, you know, and that is absolutely critical, which could then drive both the policy direction, in fact, and the legal direction in terms of the national laws. And finally, of course, importantly in this regard is actually are the international standards. You know, I mean, you theoretically don't need a policy to adopt a national law that would give effect to the right to you know, social security and social assistance in particular. Most African countries have actually signed up to the international covenant, and its interpretation is clear, as Sarah also highlighted to us. What is expected of countries in terms of making available resources, the essential core element or the core basis of the right that must always be there in place. Yeah, it's a mixed bag. You know, I would be careful to say that can and should just happen in one way. That all of these issues they play a role as far as that is concerned.
Okay, thank you very much, Marius. Yeah, the time has run out, and as I said before, some questions have not yet been addressed, but we are compiling them, and we will get back to those people via email. And so, yeah, thank you all for participating. Thank you very much to the presenters, Sarah, Marius, David, for sharing your insights with us. And thank you to socialprotection.org also for hosting this conversation. This webinar was part of the State of Social Assistance in Africa webinar series, and the next session as part of the series will be on the 9th of July. It will be on the institutionalization of social assistance in African countries. So please join us. Yeah, and please make sure to answer the survey, the webinar survey available after the session. Thank you very much and have a good day.
Thanks so much, everybody.
Thank you. Thank you very much.
Thank you.